Okay, looks like we got quite a few today. Good afternoon, everybody. Thank you all for joining us today. Wow, people are still coming. Wow.
Good afternoon.
Hi.
Okay, got more to do. Okay, good afternoon, everybody. Thank you for joining us today. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation. And we are here today in partnership with our Month of Service. And a Month of Service program, again, is a partnership between our organization, the City of Houston's Department of Neighborhood, Lonestar Legal Aid, Harris County Tax Assessor's Office, Harris County Tax Appraisal District, the Houston Volunteer Lawyers, and the TSU's Earl Carl Institute. So together we pretty much all have the same goal in mind, which is to help present information and bring information to the community regarding asset protection, asset building, and maintaining generational wealth. So as part of our month of service, there's a variety of different workshops that we bring to the community. Prior to COVID-19, we were out visiting different areas in the community and providing all of these workshops a month at a time in each neighborhood to community leaders like yourself that do not generally get access to this kinds of information that we have available. So we are here to pay it forward and make sure that we are continuing with all of our mission is to provide this information that will help benefit the people of the community at large. So again, thank you for joining us today. Myra, would you like to go ahead and give yourself an introduction?
Sure. Good afternoon. My name is Myra Hippolyte. I'm with the City of Houston Department of Neighborhoods Community Outreach, and we're under the direction of Assistant Director Landon Taylor. One of the reasons that the City of Houston wanted to partner with this other organizations is to make sure that the City of Houston communities were able to get as much information as they could, as much free information as they could, to be able to make logical decisions, not only through COVID-19, but also if any type of disaster, and even if there's no disaster, there's so many decisions a normal family have to make on a daily basis. We wanted to make sure, Mayor Turner wanted to make sure that you all had the correct information, and not only the correct information, but we wanted to make sure it was given to you in a free basis. So we're trying to give back to the Houston community because you all are always giving back to the City of Houston, and we want to thank you. And you guys have a great day. Thank you.
Okay, so today's presentation, we are going to be addressing consumer concerns related to credit and debt and fraud prevention or fraud, especially amid this COVID epidemic that we're experiencing. So today's presenter is Donna Carney with the Lonestar Legal Aid, and we are going to go ahead and have her get started because we know that a lot of you have a lot of concerns. We ask that if you have anything in particular that you'd like to have addressed, please submit your questions in the chat box, and we'll definitely make sure that we get those addressed for you. At the end of the presentation, if you are interested in verbally asking your question aloud, you are allowed to do that as well. Just raise your hand in your box there, and we will definitely call on you and unmute you so that you'll be able to directly ask your question of Ms. Carney. So, but again, please be patient with us. We are all kind of going through this process together and trying to figure some things out here. There's something new every time we do one of these presentations, so please bear with us. But again, we'd like to go ahead and get started. And Donna, go ahead and take over, please.
Okay. First of all, let me get my screen up here. Okay. Nia, are you able to see the
Yes,
slide?
ma'am.
Okay, great. Good deal. I can't see the chat box at the moment, but I'll adjust my screen later. Maybe Nia, if you want to just holler at me if there's an urgent question in the middle. My name is Donna Carney. I'm an attorney. I've been licensed to practice in Texas for 16 years. And from the very moment that I received my law license, I have been committed to representing consumers. That has also spread into other areas that are not just debt and credit related. I have handled cases related to auto fraud and now housing, tenant housing rights. But today I was asked to speak to you all about credit and debt. Some of that will touch on fraud. And I feel like the information is always important, especially important when we're dealing with a pandemic and everybody's a little bit concerned about income insecurity, and that can sometimes lead to stress that might be avoidable if you know what your rights are. So I'm really glad to be here. I want to thank everybody who pulls this program together, and I'm very happy to represent Lonestar Legal Aid here this afternoon. Let me make sure that I can forward. Okay. Before we can talk about debt and fraud, I feel like it's really important that consumers know what their rights are with respect to credit. I've listed a couple of hyperlinks here that I encourage everyone in the United States over the age of 18, and even people under the age of 18, to have a look at these different websites and contemplate if you can stand on your rights through these websites. The first one is an opt-out tool that the federal government set up for us as consumers. As consumers, you may get credit offers in the mail, and surprisingly or not, people who filed for bankruptcy statistically get more credit offers than people who haven't filed for bankruptcy. And when you get credit offers and they come to your mailbox, you open yourself up to getting credit that maybe you didn't need. We are a very society. Unfortunately, when a credit card offer comes to your mailbox, it also opens you up to identity theft. And so very often people will say, you know, what can I do to stop getting all these credit card offers? Or how many times do I need to tell them I'm not interested? If you would like blanket protections, I feel like this is a super important option that we have as consumers to opt out. And when you opt out, when you go to this website, optoutprescreen.com, you can either opt out for 5 years. You can also opt out indefinitely. And that website is also there to let you opt back in. So if you ever feel like you've made a mistake and you want to start receiving credit card offers again, you can go right back to that website and opt back in to get new offers of credit. The next link, I think, is critically important for everyone. When I've given this presentation many, many times through the People's Law School, I would usually do a show of hands and ask people how many of them had checked their credit report recently. It's usually a very low number. I want to share with you that your credit report is free to you. And not because there's some gimmick on television that's giving you a free credit report, but because the federal government once again has set up a resource where you are entitled to get a free credit report every 12 months directly from each of the 3 credit bureaus. And the big 3 are TransUnion, Equifax, and Experian. When you go to annualcreditreport.com, my advice to you from a legal perspective is that you save the report that is generated. When you visit those credit bureaus, they will generate a report accurate for the day you visited their website. If you can save a copy of your credit report by PDF, that's wonderful, and you should do that. If you cannot, you should consider printing it and saving it some other way. The reason I say that is because while you may not be the victim of any violation of Credit Reporting Act rights right now, and certainly if you are, you might become one day. You may find that one day there's information on your credit report that doesn't belong there. And if that's the case, it's always good to have an older credit report that you can reference. what's new and different now that we're in the pandemic is that the three credit bureaus have recently announced that they will allow Americans to pull a credit report every week. And so if you are concerned about something on your credit score, credit report, that is a tremendous benefit to consumers to be pulling a weekly credit report. I tell people all the time that pulling your credit is kind of like going to the doctor and checking your cholesterol. Some of us don't want to do it. Some of us don't want to step on the scale and find out what's in our blood work. But the same goes for your credit. Your credit worthiness is what will help you get the loan that you need or the modification on a loan that you need. And getting your credit report from a third party may not be the most pure source of information. So annualcreditreport.com is the only website that is approved by the federal government where you can get your credit reports for free. I don't remember the date that it will cut off, but I believe it's in about a year from now that they will stop offering weekly free credit reports. But for now, I encourage people to go get a credit report. If you find something on your credit report that does not look right, the mechanism to fix it is to write to the credit bureaus. When you do write to the credit bureaus, don't give them the opportunity to say, we never got anything from Joe Consumer. Instead, make sure that your letter to the credit bureau is sent by certified mail with a return receipt. That is your best bet. If you have a trade line to dispute, that's not your trade line, it's not your account, and you don't know why this particular car note or house note or credit card is listed on your credit report, your dispute will trigger very valuable rights. And the credit bureaus are going to deny they got your letter or your dispute unless you can prove that you did. And so certified mail with a return receipt is what I would recommend. Okay, that's kind of talking about credit. And I should backtrack just to say I kind of mentioned over the age of 18. Over the age of 18 is the age that you should be entitled to get or apply for credit. I have found in my years of experience that there are lots of credit offers that are made to minors. And so that opt-out pre-screen link that I provided a moment ago is one that you may want to access for your children, or if you have other people that you are taking care of in a legal capacity, you may want to go in and protect them from identity theft and from credit fraud by making sure that there are no credit card offers coming in their name as well. Okay, this next slide, I've titled it Debt is a Four-Letter Word. And while I can't hear if there's a chuckle in the audience, you know, I call it that debt is a four-letter word because so many consumers end up on hard times because of debt, and it becomes a bad word. People don't want to be in debt, and yet so many of us, so many consumers have debt. I would want you to know that you have rights that relate to debt collection, both under federal and Texas state law. And particularly, you have more rights if the party that's trying to collect debt from you is a third party. It's really important that you know who it is that's collecting the debt. If the account was with, let's say, ABC Bank, but it's now being collected by XYZ credit collector, you want to know why XYZ credit collector is actually sending you notices. Maybe they're a scam. And so just a couple of pointers, and I'm happy to spend a lot more time talking about debt collection rights, possibly in another conversation. But just very quickly, if you get any phone call from a third party telling you that they are collecting a debt for one of your creditors, keep in mind that within 5 days of that initial phone call, they are obligated under federal law to send you something in writing. I never recommend, I do not now recommend that you give them your date of birth, your social security number, but if they have your mailing address, you can certainly confirm that they have the correct mailing address so that when they do send you something in writing, you'll get it. When you get that notice from a debt collector in the mail, they are obligated in their first letter to tell you that you have the right to request validation of that debt. I don't want to get into all of the details. Validation of debt is not a ton of information. They will not provide you 6 months or 3 months worth of the purchases that you supposedly made. But there are certain things that they are required to tell you when they validate your debt, and that includes the amount that you presently owe and who that original creditor was. And so if you get a letter in the mail that gives you the right to request validation, I urge you to write to that debt collector. You could even take that very same letter you've received and photocopy it and just write along the top, I request validation, and just make sure to put it in the mail within 30 days of receiving it. Again, anything you send that touches on your finances that you send regular mail may never get where it's going. I always urge people to use certified mail with a return receipt if they can. That would be the best option. Also, a debt collector must stop contacting you if you dispute the debt. That's for third-party collectors. And certainly if you have an attorney, whether you're in a situation where you're being collected on by the original lender or a third-party debt collector, if you are represented by counsel, they're not allowed to call you anymore. They must communicate with your attorney. There are lots and lots of other rights. I don't know that we have time to get into all of the consumer protections related to debt in this conversation, but I would want you to know that you do have rights when it comes to debt collection, and you should consider either getting yourself educated on that through other series like this or contact an attorney. Okay, what happens when your debt is in default and your lender, your creditor, or a debt buyer decides that they want to sue you for that debt? And the one defense that we see all the time that never works is what I call the Ostrich Defense. And that is the defense where the person says, I'm just going to go stick my head in the sand and I'm going to hope that this lawsuit goes away. I'm here to tell you, having practiced for 16 years in Texas courts, doing nothing and avoiding the lawsuit, pretending it didn't happen, thinking maybe the process server didn't really get you because you didn't have to sign the papers, none of that makes the lawsuit go away. And where a debt may not touch you or your bank account, a judgment can. And so we want to do what we can to make sure people understand if there is a lawsuit against you on a debt, on a consumer debt, please do something about it. If you cannot afford an attorney, if you are not eligible for legal services through organizations like Lonestar Legal Aid, then at a minimum, please file an answer for yourself on a pro se basis, or kind of self-representation as we call it. There's a report that came out, I want to say maybe 2 weeks ago or so, by Pew, which is, they do more homework, I think, than any other group in the country on issues like what happens in the courthouse. And the report was mind-bending for the amount of debt that ends up in our courthouse. And specifically, they quoted, there's a quote that I put in here regarding Texas, the only state that had enough data to show that the number of debt collection lawsuits doubled in our courthouses from 2014 to 2018. And that accounts for 30% of all civil litigation in that 5-year period. So if you have a debt and it's gone into default and you're being threatened with a lawsuit, if that debt is under 4 years old, you may get sued. If you do get sued, I'm urging you not to avoid the lawsuit by pretending it'll just go away. And I put the link down at the bottom if anyone is interested in reading the report out of Pew Trust. It's just fascinating to see how much of our litigation machine is couched in debt collection. The second quote that I put in here is equally important and has to do with this Ostrich Defense. About 70% of debt collection lawsuits do end up with a default judgment. And a default, as it indicates, is the kind of judgment where you, the defendant, you've received a lawsuit and decided not to do anything about it. It's very easy for the courts to simply rubber stamp a judgment, and the data shows 70% of those lawsuits will end up in a default judgment. Okay, what happens if you have a judgment? Or a lawsuit, let's say, what is the worst case scenario? Well, the worst case scenario would be a judgment. And there are several different types of ways to get to a judgment. The first and the easiest way that we just spoke about is the default judgment, and that is where the defendant did nothing. I would want you to know that hand in hand with the statistic that there are a lot of people who supposedly don't answer their lawsuits, there are also a lot of people who really never truly got served. And so if you come to find out that there's a judgment that was ever entered against you and it resulted in a default judgment, but you never got served, no one ever came to your door and said, "Are you Joe Consumer? Drop the papers in your hand, you are now served." You may have rights to vacate or unwind that judgment. I also would want you to know that it doesn't matter how old that judgment is. If you never got served, then you've lost out on your right to due process. It's kind of this constitutional right that we all have to be able to appear in court and defend ourselves. Just because there's a judgment against you, and certainly if it's a default judgment against you, doesn't mean you just have to suck it up. I would want you to do your homework and find out, where did this default judgment come from? When was this lawsuit filed? Where was it filed? Who's the creditor? Did they get the right Joe Consumer? Or is my name so common that they stuck this with me, but it really belongs to someone else? There are two other kind of judgments that I listed here. The summary judgment, you may end up with a verdict, a bench verdict, trial by judge or jury that would result in a judgment. In any of these scenarios, if you end up with a consumer debt judgment, you should anticipate that the collection industry will do what they can to get paid. What that typically means, and how we typically see judgments getting collected on, is where the judgment creditor or the plaintiff will ask the court to either issue a writ of garnishment. They can issue this writ of garnishment, which will allow your bank to effectively freeze the money in your checking or savings account. We often see that there are receiverships that are put into place. We used to only hear about receiverships when it was huge entities, corporations, or super wealthy defendants who might have been trying to hide their money. Receiverships were never typically used for consumers with relatively small judgment amounts, but we are seeing a lot of receiverships these days. And a receiver is an intermediary attorney who will help the court and the judgment creditor get to your assets, including your bank accounts. So both of those, whether it's a garnishment or a receivership, both of those will end up with a potentially frozen bank account. You may have some exempt assets. It just depends on your financial situation. You may have some money that's in a retirement account. You may have money that's coming in from Social Security or some other exempt money that cannot be taken away from you. That money cannot be frozen. Some of that liability will be on your debt collector, the plaintiff. Some of that liability will also be on your bank. And in any event, the person who really has the power to help themselves is you. And so if you do come to find out that there's a garnishment or a receivership or a threat of one of those, I think the most important thing you can do is pipe up. And at the very end, you'll see I have a slide that says, what can I do? What you can do is communicate, is pipe up. And very often you'll hear the debt collection industry say, give us a call. You have a judgment and I was the lawyer in the judgment against you. Give me a call. I'm a debt collector. I'm a nice person. I'll help you out. You may want to call the debt collector. I don't think there's any harm in talking to a debt collector to try to work out a settlement. But I would advise you to try to find a consumer rights angle on it. And so if you qualify for services with legal services with Lonestar Legal Aid, by all means, call and put in an application, see if you're eligible and see what your rights are. If not, there are other resources that are available to help you get through your rights. And for homeowners, this is really important. If there's a judgment against you, they cannot, depending on who took the judgment, but on a regular credit card or automobile deficiency from a repossession, if there's a judgment in one of those situations, the creditor cannot go in and put the sort of lien on your house that would sell your house out from underneath you if that house is your homestead. We do have homestead protections in Texas, and no one can sell your house out from underneath you for a debt that's not related to the house itself. So if there's a mortgage and you owe money on the mortgage, you may need to give up your house. But if your debt has to do with a Target bank card or Ford Motor auto deficiency, even if they get a judgment against you, they can't take your house away from you to satisfy that judgment. What they can do is they can file what's called a judgment lien. And that judgment lien will sit there as it's like a spoke in the wheels, and it will get your attention if and when you ever try to sell your house. There are ways around it. There are ways to do what's called a partial release, and that will allow you to eventually remove the cloud that kind of casts a shadow on the title to your house so that you can sell your property. But very often we learn about judgments because people do try to sell their house and they say, you know, I found out I have a judgment lien. I never even knew I had a judgment. I never even knew there was a lawsuit against me. And so once again, those are kind of red flags, not necessarily that you did the Ostrich Defense. It could very well be that you never got served or you weren't properly served. And so you do have rights in those situations. Okay, so in the middle of all of this, and we have our credit rights and we have our debt collection rights, you know, credit and debt and managing money can be complicated and overwhelming. And then we have this pandemic on us, and this pandemic has really made things very complicated. We see and hear reports about lots of people with income insecurity, people who have lost their jobs, are not yet getting money from whatever source it is, whether it's a stimulus check or unemployment benefits that they feel like they're entitled to. We are all aware that the Texas governor put us in a state of emergency. We've been hearing reports from the CDC and from other organizations as well, from our county officials. So while we were under these emergency orders, the Texas Supreme Court was the hot spot to kind of get any relief for consumers. We were very happy to hear and to learn that the Texas Supreme Court justices were willing to extend some protections on an emergency basis. Compared to other states, we may not have nearly the same amount of protections, and yet the Texas Supreme Court was willing to implement some protections during the pandemic. We had orders that were in place. I'm not going to get into every last detail on the emergency orders that were issued by the Texas Supreme Court, but there were orders in place that protected consumers for a certain amount of time when it came to garnishment and receivership. So anyone who had a judgment, and if you are one of those people who had a judgment and there was a garnishment or receivership that went into effect while the emergency order was in place, then you had rights at the time to avoid that post-judgment collection. One of the reasons I'm not going to get into all of the details on those emergency orders is because as of this past Monday, the 18th, by and large, they have expired. Most of the deadlines that the Texas Supreme Court had implemented are now done. That is to say that garnishments and receiverships will be picking back up. There was no service of process on certain litigation. We are now seeing all of that kind of coming back, and we're seeing a revival of service of process and new garnishment and receiverships. What I would want you to know if you get notice that your bank account is frozen is that you may not be aware just from trying to get into your bank statement online or trying to make a purchase, whether your bank account has been frozen by a garnishment or a receivership or for some other reason. The number one place to go get probably the quickest information is directly from your bank. If you can get on the phone with your bank, or if there's a lobby that's open where you can actually go in and speak with somebody, hopefully through a mask, protecting the population, you want to find out on what authority did you freeze my bank account. You're entitled to know that. It's your money. The other way to find out is to go to the different courthouses. So depending on which county you live in, some counties have this information on an electronic basis. I know Harris County does. If I'm not mistaken, Montgomery County does for most of its courts, maybe not for all of the justices of the peace. And same for the outerline counties. If you are a resident of City of Houston, but not necessarily in Harris County, you want to look up your information, your name in particular, with the court records and see if there may be a judgment that was issued against you. Find out if it was a garnishment or receivership and go from there. Yes, you may find yourself encouraged to reach out to the debt collection lawyer or the debt collector, the judgment creditor. I don't think it's the wrong answer. I just don't think it's the best answer. So yes, while you might try to work out some kind of solution or resolution with the collection industry, my number one bit of advice to you, if you are going to negotiate with a debt collector, and certainly if there is a judgment that's involved, is whatever the terms are that you all are agreeing to, make sure you get that in writing. If it's not in writing, it's going to be your word against the other side. And as long as there's a hold on your money, that's a problem. If you haven't parted ways yet with your money, you certainly don't want to give away bank account information or anything like that until you do have an agreement in writing. The one order that the Texas Supreme Court has recently put into effect and still exists, is still a helpful order, relates to stimulus funds that some of us received through the CARES Act. So just very briefly, the CARES Act is the new law that the federal government passed. The number that everybody was kind of hearing in the news was $1,200. That was approximately kind of the lowest amount you might receive if you were eligible, if you have no children, that sort of thing, or young minors, dependents at home. Some people were getting stimulus checks that were over $1,200. The only protections that we have right now from the Texas Supreme Court relate to those stimulus checks, and they don't exempt that money from any collection, only in some very limited circumstances. So what I would want you to know about this is, if you have a garnishment or a receivership that's brand new implemented against you, whether it's on a judgment you know about or one that's a surprise to you, any money that you got from the federal government that's a stimulus check is going to be protected. You are entitled to a really quick hearing. I believe the Texas Supreme Court wants these to be heard within 2 days by the courthouse. It would be up to you to get in touch with the court, whether you do that directly or through an attorney, to say, we need to stop this right now because those X number of dollars that you've frozen are stimulus money, and that is not allowed. Okay, just let's see just very quickly what the CARES Act has done in terms of trying to protect, from a housing perspective, tenants and homeowners. The emergency orders that we have in place from the Texas Supreme Court, there was a separate order that did address tenants and evictions. That one is also expiring as we speak. I don't want to spend a whole lot of time on the eviction and tenant angle or for renters. Although we do have information on that if anybody needs information beyond this presentation. There are aspects of the CARES Act, this federal statute, that will protect homeowners. And to the extent that some of the audience here may be homeowners trying to protect your assets, I would want you to know that there's not just a foreclosure moratorium and that's it. It's not a situation where just don't expect you're going to be foreclosed on and that's it. That's not what the law says. The law does say there will be a pause on foreclosures right now. There are certain circumstances, though, certainly if your mortgage is backed by the federal government, whether it's Freddie Mac, Fannie Mae, there are many other iterations of that. Yes, you would be protected from foreclosure, but I think it's really important that you recognize as a homeowner that you still have an obligation at some point to be making payments. And if you are not covered by a federally backed mortgage, you will want to get in touch with your servicer. I would not want anybody to just rely on the fact that there shouldn't be any foreclosures going on right now without anticipating that down the road, you, first of all, may have to talk to a servicer if you are not federally backed. And second of all, there may be other consequences. And so what we hear in the news may sound like a really helpful blanket to everyone. And I would want you to know that different homeowners may be in different situations, and you will want to talk to your servicer to find out. If you feel like your rights are being compromised, I cannot stress enough that you'll want to go either get your own education on this, or see if you can't find the advice of an attorney to give you proper homeowner and consumer rights advice. Okay, so I'm up against my last slide. I will open up the floor to questions. You know, the big question is, what should I do to protect my bank accounts or my household? And I had mentioned ask for assistance. And I am convinced you will hear lots of your creditors communicate with you on the monthly bank statements that they send you, on the monthly credit card statements, whether it's your car loan, you may get a written statement from them in the mail, telling you, if you're having a hard time, reach out to us, contact us. I don't think it's a bad idea. I just think that that shouldn't be the only place that you go find out what sort of relief you might be entitled to. And so, yes, you can ask for assistance. If you come up with any agreement with your lender or creditor, and certainly with a third-party debt collector that you feel comfortable with, you want to get that in writing. I think that I maybe ran through the information on a relatively quick note, and I hope it was helpful. I want to not unshare my screen. I'm going to minimize this PowerPoint just briefly so I can see if there are any questions in the chat. So you guys will pardon me for that for a moment. And I am welcoming any questions. If anybody does have a question, please feel free to chime in.
If there are any questions, you can also raise your hand and we can call on you directly to ask, as opposed to just typing it in the chat box.
Okay, so we have one question from Eric asking, if I have a credit freeze in place, can my credit still go up or down? That is a great question. I'm gonna give you the answer that you'll probably not hear very often. You ready for it? Nobody will tell you how your credit score is impacted. The credit bureaus hold that information so close to the vest. And FICO, which was one of the original credit score manipulators, I call them, never issued a handbook on it. Can your credit still go up and down? I think you will know the answer to that sooner than I will if you try. If you try to get new requests for credit while you have a freeze in place, that may negatively impact your credit score. Your credit score will take a negative hit if you try to ask for credit, even if you don't have a freeze in place. People who try to get more credit than they may be entitled to will see their credit score drop. If you use more credit if you use a greater percentage of the credit that's available to you than normal, you will see your credit score drop. At the same token, if you start paying off your debt, if you have a very high amount of debt compared to how much credit you have left, you start paying that down, you may see your credit score go up. If you close accounts and you kind of make the pool of credit you have smaller, you may see your credit score go down. I don't know for a fact that putting a credit freeze in place will also freeze your credit score. I've never heard of that. I'm not aware of that. Okay, we have another question. If a company's never reported to your credit history for 3 years, can they start reporting when you fall behind? That is a great question. I'm going to answer it this way. If you have been on time for 2 years and your creditor has never put in that information and they suddenly want to start reporting the one time that you've fallen behind, I would encourage you to write a dispute to the credit bureaus. And since we're on this topic, I want to give you some advice on how to write to the credit bureaus. Most people don't know what it takes to dispute their credit report problems. before I kind of tell you to go grab, while you're out grabbing a pen and paper, as I encourage you to go grab a pen and paper, I will tell you that in my first several years in the practice of law, we used to see lots and lots of lawsuits filed privately and by the various attorneys general throughout the country, including the Texas Attorney General, against companies that called themselves credit repair companies. I would encourage you to dispute your credit problems on your own. You can do it. It's easy and it's free. And if the credit bureaus don't fix whatever the problem is, and if you're entitled to have that information fixed, then you are effectively helping yourself, setting yourself up for a potential lawsuit against the credit bureaus to protect your rights. I'm not telling you not to use a credit repair company. I would encourage you to do a lot of homework before spending money to do something that you can do for free. So what would you do in that situation if you've had months or years of great credit reporting history and then your creditor decides to just report when you've stopped making a payment? Your letter to the credit bureaus goes like this. This is for any dispute. If you'd like to take notes, this would be a really good time. You certainly want your letter to look like letterhead. Make sure to put your name on it. You want to include your address where you presently live, and you're going to want to put a date on it. You can send one letter to all 3 credit bureaus, but if it's only one credit bureau that has bad information on you, you could also just write to that one credit bureau. Typically, you'll find the mailing address for the credit bureaus on the very last or one of the last pages of your credit report. And you'll want to take a photocopy out of your credit report that has the information that's incorrect or that's not been accurately reported. And let me just pause and put in parentheses here that the Credit Reporting Act, the federal and the state laws that protect you require your creditors to report accurate information. And so for a creditor to just decide to report now that you're behind, I would argue that's not really accurate. If you want to report this 1 month that I've fallen behind, well, you're going to also need to report all of the history going back. And so your letter will start out with your letterhead, your name, your address. Make sure you put a date on it. You're going to address it to the correct party, whether it's one or all 3 credit bureaus. It's a 3-paragraph letter. And please don't be overwhelmed. It's very simple. I'm going to give it to you. Your first paragraph is going to be a paragraph identifying yourself. You'll want to include your full name. If you've recently changed last names within the last 2 years, you'll want to include that information. You can list your date of birth. You can even include your social security number. I don't have a problem with that. If you've moved in the last 2 years, you will also want to put your prior residence addresses. This letter is only going to the credit bureaus. They already have your social security number. I'm encouraging you to send this letter by certified mail with a return receipt so that you can track it. So that information in the first paragraph will simply help the credit bureaus identify that you are who you say you are. Your second paragraph is a paragraph where you will lay out what the problem is. You can let TransUnion or Equifax or Experian know, look, on page 4 of my credit report, you've listed such and such motor financing. Such and such has been accepting payments from me on my vehicle for 3 years, but they haven't been reporting my payments to such and such auto finance for all 3 years. They've only reported the last payment. So just write out in your second paragraph what the problem is. If you have evidence to support your contention, whatever it is that you want the credit bureaus to pay attention to, you'll need to include it. So you'll tell the credit bureau, I am attaching a copy of 2 years worth of payments that I have made to such and such auto finance to show that I have been paying on time. If you are not going to delete this 1 month, then please make sure to at least include the prior 2 years. So your second paragraph will lay out the problem. Your third paragraph is your demand. And I think sometimes we are reluctant to use that word demand, but I would encourage you to start your third paragraph saying, I demand, and tell them what you're demanding. I demand you delete this improper information. I demand you also include all of the positive credit history with such and such auto finance, whatever your demand is. When you make your demand, tell them why you are making your demand. I am demanding this because it is going to prohibit me from getting a new house. I won't have good credit for a new car, and that sort of thing. And so I would want you to be very clear in your first paragraph identifying yourself, second paragraph identifying what the problem is, third paragraph make your demand and state why. Make sure to sign the letter. I encourage you to also send it certified mail, return receipt. You're going to keep a copy of everything you've sent, maybe even start a folio, because you're entitled under federal law to get a written response from the credit bureaus. And so that is really important that you keep all of your paperwork. I hope that may have been a greater answer for a small question, but that's what I would do. If they continue to not report all 2 years going back of credit, that's positive credit history, at that point, you may have a claim under the Fair Credit Reporting Act or under the Texas Finance Code. Those are the Credit Reporting Act statutes. And for that, you will likely need the assistance of an attorney. Okay, I'm going to scroll back and see if there are other questions that I've missed.
Yes, Ms. Peggy had a question. She wanted to clarify, did I understand you correctly to say that during this pandemic, I can get a credit report weekly at no cost?
That is correct. The link that I gave earlier, and I will skip right back to it, annualcreditreport.com. You should find, I may try, I don't know if we are connected here, if I can link to this and still share it. Open link. Let's see if we can share the screen. Can you all see the annual credit report screen?
No, unshare the screen and then reshare it again. Yes.
Okay, hopefully you can see that now.
Yes.
I'm pointing, can you see my mouse here, the pointer?
Yes, ma'am.
They say during these times of COVID, accessing your credit report is important. I don't always agree with the credit or debt industry, but in this situation, I agree with them that accessing your credit is important. And so all three of the credit bureaus are now offering a free weekly online report through April 2021. I thought it was about a 1-year period, so a little shy of 1 year. I don't know that you need to be checking it every week, but I encourage you to check it. Check it when you have time this weekend. Check it every few weeks. If you have something on your credit that is not accurate, you will want to check it. You'll want to check it every several weeks until it gets cleared up. You will probably get a link through the different credit bureaus' websites to dispute online. I don't recommend it. I just don't recommend that you do those disputes online. My recommendation is that you put pen to paper. Your penmanship, your spelling don't count. Lick a stamp, go to the post office. If you don't have the wherewithal at home to send the letter certified mail with a return receipt. That is my recommendation. If you cannot leave home because of the pandemic, even to go to the post office, I certainly respect that. If you intend to lodge your dispute online, I would strongly encourage that you create a screen capture, take a picture of every step of your dispute process in a way that it's date stamped, and send yourself a copy. If they give you an opportunity to send yourself a copy of your dispute, ask for it, because at some point the credit bureaus may say, we never got that dispute, and you'll want to have proof that you did in fact send it. I hope that answered that question. This last slide, I hope you all can see it. This very last slide, you have a link here. LoneStarLegal.org is our website for Lone Star Legal Aid. The main number is also listed here at the bottom. You're welcome to call in or go to that website if you are looking for legal services. If you qualify, there is an intake process. You'll find a link to the intake process directly from our homepage at LoneStarLegal.org. Do we have other questions?
Yes, Donna. a person that is not on web asked Sequel, what about faxing instead of sending it certified mail?
You know, I'm not aware, I may be outdated on this, but I am not aware that the credit bureaus have a fax line. If I'm wrong, and if they offer you a fax number, that would be great. Your fax is only as good as your fax confirmation page. If you're working on a fax machine that cannot print out a fax confirmation page, I think you're in the same spot as having sent them a text message or US mail without tracking or certified or registered return receipt. So if you find that they have a fax number, go for it. It's not my number one preference. I don't know where those faxes go. I don't know if they generate an email that's later populated into your account with the credit bureau. And if I'm not mistaken, that's G-Call. I believe that's somebody from my office. If you come to find out that there is a fax number, I would love if you would just update me so that I'm on top of what's going on. I am not aware in the years that I've practiced that the credit bureaus actually offer a fax number. Having said that, if you're going to be communicating with your lender, or if you're communicating with a third-party debt collector or the lawyer for a collection agency, I don't have any problem with you communicating with them by fax. I think that's fine and that's fair. Again, just make sure you have a fax confirmation page. Okay, other questions?
Again, you guys can feel free to raise your hand and we can call on you so that you can ask your questions verbally as well. You have that option too. I know it can be a bit much to try to type a question and get your point across in a chat box.
You know, I may just take a moment and give, if anybody has a question, give them an opportunity to type in their question. I believe that the title for this presentation included the word fraud, and I just want to touch on that maybe briefly. Fraud is everywhere. Fraud is kind of a business model for lots and lots of different companies. When it comes to credit and debt fraud, I really feel it's important that you do check your credit report and you check it on some regular basis. I typically, outside of a pandemic, encourage people to check one credit report every year and maybe wait 4 months and then check another credit report so that you're basically looking at your credit throughout the entire year. That may be a lot for some people to keep up with that. So at least once a year, at least once every 12 months, maybe around your birthday, go pull your credit reports and see what's on there. If someone has stolen your identity, or if you've shared your identity with a company and now they've opened multiple accounts for you, we've heard of plenty of that. Wells Fargo was tapped for having done that several years ago, where they opened lots of accounts for people who didn't ask for anything but one account. That is where the dispute process, that will come into play right there. I will tell you that if you have identity theft going on and that sort of fraud that you're contending with, the credit bureaus may accept one dispute letter from you. They may do something with it and they may not. You would be one of a huge number of statistics that is dealing with identity theft. If you really want to get the attention of the credit bureaus and your creditors, you will need to file a police report. Some people hear that and they automatically cringe because they know that the person who has stolen their credit may be their family member. And that's also a statistic. We hear a lot of that. But I can tell you from my experience that the credit bureaus will not give you a lot of attention to remove something from your credit report unless you can show a police report. And so you may need to make a phone call. I don't know how the authorities are handling that these days with the pandemic, but getting a police report will require you to speak with somebody, a police officer, or if you're out in the county, whoever your authorities are, and ask them for a written report with a complaint number. You will want to attach a copy of that report to your dispute letter that goes out to the credit bureaus. And at that point, you have effectively taken the responsibility of an accurate credit report, where the credit bureaus might have said, well, we had no way of knowing that this was identity theft. We had no way of knowing that you didn't open this account, Joe Consumer. Well, now you do know. Now you know, and I've told the police, and the police have generated a report, and now credit bureaus, now it's on you to close out that account from my credit report. In those instances, you probably want to send a copy of that letter to the lender as well. And most credit bureau reports will show you the full mailing address for the lender with whom you can communicate. Again, certified mail return receipt. I want to maybe add a comment that we hadn't talked about. If you're going to talk to somebody over the phone, this may be your lender, this may be the mortgage company, this may be a collection lawyer, you have the right in Texas to record your phone calls. The reason I say that is because sometimes you will find yourself in a situation where you're coming up with a really decent repayment agreement with your landlord, with your mortgage bank, maybe on your car note, and you ask them to send you something in writing, and they may decline. They may say, you know, we're real busy, we'll try, we're just going to update it in our system, you'll be fine, you can defer a payment or two. Or if you have a recording of that conversation, that is great evidence. And so the law in Texas says that as long as you are on that phone call, you can record that phone call. You don't have to ask for permission to record the call. You don't need to even notify them that you're recording the call. Just go ahead and record it. These days, you can get an app for most smartphones, either for really, really cheap or for free. And so if you can't get something out in writing because of limitations getting to the post office or that sort of thing, you don't have access to a fax with a fax confirmation page, it's a far worse way of gathering evidence, but you could keep a recording of that phone call. Okay, there's a question, is Lonestar service free of charge? It is, in fact. I don't think we've ever charged a client ever. And I only say that a little tongue in cheek. We are funded in a way that we can provide free services to low income Texans. You would need to qualify for legal aid services, but yes, if you qualify, we do not charge our clients for our time. Okay, any other questions?
Yes, I have a quick question, Donna. Have you seen or noticed any additional scams or fraud activity that's been going on since COVID that people should kind of be aware of?
So the one that I had heard of recently was, I'd heard this on the news, that some people were getting phone calls related to stimulus checks, and they were being told, you know, if you give me your social security number and your date of birth, we will, you know, see if you qualify for this second round of stimulus check. A lot of people fell prey to that. When you give out your social security number, and certainly if you give that out along with your date of birth, you've effectively helped a criminal commit their crime. I'm not saying that in and of itself is criminal, but protect yourself. There's just nobody who is entitled to get your full social security number over a phone call ever, period, end of discussion. Sometimes you will get hammered with, you know, I need your social security number. Okay, just give me the last 4 digits. I wouldn't even recommend that. If you're placing the phone call, you should know who you're calling, and they may ask for the last 4 digits of your social security number to confirm your identity. But if you are receiving a phone call, I would never, ever trust that the number showing up on my phone or the person telling me who they are is in fact who they are. There are just too many fraudsters out there trying to rip people off. And that may be a big one that I've heard.
Okay, great. Are there any other questions in regards to consumer concerns or credit or debt or fraud or anything that anybody may have? Please feel free to chime in.
Looks like that's a wrap.
Yes, you guys have one, there's one question.
Let's go ahead. Go ahead, Liz.
Yeah, hi. In regards to the credit card fraud and getting the police report for that, there was a situation where someone was using the social security number and established a credit report for a minor. And when that minor became of age, realized that the social security number had already had a credit report established. Called the police, but the police said unless there was a harm, which the only harm was there was a duplicate credit report, there was nothing that they could do. Is that the case?
You know, I will tell you, in all of my years of practice, I think maybe one of the small points of disappointment that I've heard, and I say this gently because, you know, we do get a lot of protections out of our police force, but this was always been a sore spot, is requesting a police report on identity theft. I have heard that so many times that we can't help you, we can't help you. What I would advise the individual, the now adult who was a minor at the time that somebody used his or her credit, is to explain to the police officer, I'm not actually asking you to fix this problem for me. I'm not actually asking you to run an investigation or deplete your resources on this. I just need you to take down my complaint and put it in a report so that I can send it to the credit bureaus. At the end of the day, the credit bureaus are not going to circle back to say to the police, whether it's HPD or any other police force, you know, what was the result of your investigation? Why isn't there a criminal conviction here? That's not what this is about. There may be room to open an investigation and a criminal, you know, complaint and maybe a prosecution. Probably not. I think that we see a lot fewer investigations regarding identity theft than we do, unless it's on a huge scale. The credit bureaus just need to see that you've actually filed a complaint. That's what the credit bureaus want to see. In that particular situation, though, I might say that there's another angle to address it. If that consumer, let's say that consumer's now 18 and a half years old, if that consumer at any age can go ahead and get a copy of their birth certificate, maybe their passport, driver's license, any identifying document that shows their date of birth, they should be able to take that up directly with the credit bureaus to say, here's my date of birth. This account was opened when I was 12. I couldn't have opened it myself. Now you need to delete it from my credit report. So I don't know that you would necessarily need to have a police report for that. It would probably be helpful, but just simple math on a formal document like a photocopy, and that consumer would want to include a photocopy of their driver license or birth certificate, that sort of thing. I think should get the job done. That's a great question.
I would also recommend that within the police department, when you're contacting them, and I remember from our previous workshops that you specifically talk to the consumer protection or the fraud division of the police department. So don't just call and talk to the general person or whomever is answering the phones, to specifically talk to that particular department or have them give you the phone number for that particular department to contact and then go from there. Because a lot of times, you know, unfortunately, when you get that one officer on the line that's just there to answer the phones or whatever, you know, that's pretty much what they're going to tell you. But there is a consumer protection division within the police department that only handles scams and fraud and things of that nature.
Great, thank you for that. And just as a follow-up, the credit bureau, what they did was just tag the credit report to indicate that somebody else had used the same social security number. So that was as much as we could do to fix it.
I would probably consider taking it a step further if, and this is a big if, now I'm kind of wading into legal jargon, if that consumer has damages. And so the Fifth Circuit, where we're located for federal, especially for federal litigation, if you wanted to pursue these claims under federal statute, case law is pretty clear that you need to show some measure of damages. If that consumer has disputed with the credit bureaus to say, my social security number appears with new information that's not mine, someone has been using my social and in a way that's harming me, please remove this. and then the credit bureaus don't remove it, and then the consumer goes out to try to buy a chair with, financing from the furniture company and is declined, then that consumer has damages. Or if that consumer tries to get auto insurance and doesn't get the best premium, the best rates because of a poor credit score, then there are damages. But the Fifth Circuit, kind of the area where we're located, for people who are not lawyers on the phone call, so that you have a better understanding, the Fifth Circuit has limited the rights of consumers to go into court and bring a claim, a lawsuit against under federal law against the credit bureaus, unless you can show that you have some damages.
Thank you
All right,
very much.
thank you.
Okay, I have one new message, which I'm not understanding.
Ms. Peggy, could you elaborate on your question? I am going to unmute you for just a second. Go ahead. Can you elaborate on your question, Ms. Peggy?
Yes, I apologize. I hit send way too quick. The question really, I'm about to hit it. Could you explain how to put a letter of explanation in your credit file? For example, if you are the victim of a timeshare scam or some unusual, exorbitant medical expense, something like that.
Yeah, I kind of have two minds about those kind of disputes, and I'll tell you why. First of all, if you dispute, I'll just answer simply. If you make a dispute on a particular trade line and the credit bureau declines to accept your version of the facts, they will let you know. And if they don't let you know, I'm letting you know that you could write them back a second time and say, I'm still disputing this, it's incorrect. I would like to put a note in my own credit file. Typically, they will offer that to you. Here's why I'm of two minds about it. At some point in the last 5 or 6 years or so, after we had seen tons and tons of credit repair companies charge consumers lots of money to go clean up their credit reports, the industry found out that what was happening was people who had no reason to file a dispute or lodge a dispute were just unhappy with their credit. So they would go pay a company, and that company would just dispute everything on their credit report. Some things would fall off, making the credit score go up. Some things would still stick. Some things would fall off, but only temporarily, long enough for the consumer to go get a way better credit score, a brand new lock-in on an interest rate for a new home loan, and then go on with your life. What typically ended up happening, though, was that so many of these credit repair companies were a scam that the credit bureaus needed to put a stop to it so that the credit reporting was accurate, or is accurate, as it's supposed to be under federal law. The result is that lots and lots of consumers still today, we're not quite 7 years past that time period, will find that they have notations that they had disputed particular items on their credit report. Now, why is that a problem? That's a problem because if you go try to get new credit with a big lender, they may say to you, Peggy, we really like you and we want to extend credit to you, but you have this dispute here. Well, we're not sure why you're disputing it. If you didn't have this dispute, even if you still had that derogatory information that you owed the money, but if it only wasn't in dispute, we would be able to seal this deal. And so what consumers were finding themselves in a position to do was one of two things: either live with it until 7 years had passed and the information fell off their credit report, or worse, write back to the credit bureaus and to those lenders and say, I'm not disputing this anymore. I'm going to own up to it. And while that may not have triggered the statute of limitations for brand new debt collection or lawsuits for that debt, it sure doesn't look good. So be really, really careful before you start adding dispute language to your credit report. I think it may be a better option to go litigate that issue. And you mentioned timeshare. Timeshares are just notorious for getting people into deals that they had no understanding of what they were getting themselves into. And yet, it's really, really hard to unwind a timeshare deal. It's really, really hard to get that off your credit report. So just putting in a dispute to say, I feel like I was scammed or I was duped into this, it's probably not going to help your credit score a whole lot, and it may prevent your future lender from trusting you for lack of a better word. It may put you in a worse situation. I hope that information's helpful.
Yes, very much so. Thank you.
Mm-hmm. Other questions? I can't see if people are raising their hands, but Mayor and Nia, can you see if anybody else has their hand raised?
They're not right now. And do we want to end the presentation, or are there any last questions?
I think we can go ahead and start wrapping up then if we don't have any additional questions. I just wanted to thank everybody again for, I guess I should probably take the video off, huh? I'd like to thank everybody again for joining us this afternoon. We are going to launch a poll while we are wrapping up, just to get your input on the presentation for today. I would like to encourage you to share some of the information that Donna presented today with family members or friends, or encourage someone to actually attend some of our other workshops that we've actually had as part of our month of service. We will be bringing this one back again next month. If you would just go to the nrcdc.org webpage and go to the Get Registered tab, you will see our calendar of our June workshops that are already scheduled there. And in addition to this consumer credit and fraud, there will be a disaster preparedness workshop, more information about property taxes, exemptions, deferments, let's see, what else is it? Wills and estate planning, especially during COVID, clearing title. What else is there, Myra, that I'm forgetting?
How to create your own estate plan.
Yeah. If you had particular questions in regards to the mortgage or foreclosure prevention amidst COVID, evictions and your rights for tenants or for renters, we have those workshops as well that are scheduled. So we definitely encourage you to come back and attend some of the other workshops. And again, this one is being recorded, and we are in the process of trying to launch how we can get this presentation represented to those of you that may know somebody that would be interested in listening or viewing this information again. So we will send out notifications to let you know when that recording becomes available online for you to get access to. But again, Donna, thank you with Lonestar Legal Aid for presenting to us today. A wonderful wealth of information. Thank you. I was taking my notes as I was going here too for some things that I wasn't aware of. So again, thank you very much. Thanks.
Thank you all for having me. Thank you. I appreciate it.
Thanks to all of our partners. I guess, do we want to continue to keep the poll there for just a few more seconds to get everybody? And then we will want to go ahead and kind of wrap up, and let's open up everybody and telling them thank you.
Yes. Make sure, we just want to say thank you, and what you all can do is release your video so we can see you.
Yeah, somehow. I mean,
Everybody there? Hi, Aaron.
yeah, that from the beginning that they had a set.
It's been a while.
They violated the lease. They violated.
Julie, thank you for joining us today.
On the lease 31.1.
Hi, Patricia. Thank you for joining us.
To substantially comply with all applicable laws regarding safety, sanitation, fair housing. So I went by that, so that's why I was trying to and I gave him the notice.
Yeah, I think we need to
then
mute.
the coronavirus thing came, and I could not leave after that. So
you gave them a notice. When? Do you have it?
Yes. I just muted.
Much for joining us today.
And thanks again.
Thank you, everyone.
Grateful.
All right, we're going to wrap up. Talk to you soon. You guys take care and stay safe.
Thank you, guys.